I hate to say this, but the larger the institution, the more problems I've seen that if you're just making an account pay on death into the trust, if somebody becomes incapacitated, they're not accepting the power of attorney. They're telling you, I'm Jeff Mersace. I am also known as the Plain English Attorney. I actually did get a registered trademark for that for the media that I do. I do have a bunch of resources out there that you're welcome to take advantage of. This is stuff that's kind of freely available to my clients too. There are some more advanced courses for sale that are referenced in there, but don't worry about that stuff. So I do have actually 2 courses. One of them, it's not even up there, freetrustcourse.com, and that's actually got access to my book, Estate Planning Basics, as well as the questionnaire that we use and a little bit about estate planning. So it's enough to give people a little bit of a background. I just put up about 2 weeks ago, freemedicaidcourse.com, which talks a little more about Medicaid planning and the different rules. And it's got my book, The Long-Term Care Solution, in there. We've got the online Raleigh Wills. We're still working on that. The Estate Crash course is an actual paid course that goes a lot more in depth, and that's something that it is focused more for clients as opposed to professionals. So you're not going to get any tips or skills or whatever else as an estate planner. It is more for the general audience. Estate Planning Basics book, hey, you can get it for free as an audio or a PDF at Free Trust Course, but if you actually want the book, the physical book, it's available on Amazon, and that link will get you there. And the big one, my YouTube channel, if you go to youtube.com/NC Lawyer, I have a ton of videos. We get long form videos that go up once a week. And we have 4 or 5 shorts a week, posts, and a whole bunch of other stuff. And I'm just constantly putting out information on estate planning, Medicaid planning, and stuff in those related fields. And there are some specific webinars that I put in there. There are 2 that I have out on long-term care planning, and they're free. Payforlongtermcare.com and MedicaidPlanningWebinar.com. Generational protection planning, and that's actually a nice way of saying, hey, I really don't trust my son-in-law or daughter-in-law, and I need to do planning to make sure everything bypasses them. It's inlawplanningwebinar.com. And special needs estate planning, I do have a lot of clients who are parents of special needs children, and it's specialneedsplanningwebinar.com, and revocable living trust funding, there's trustfundingwebinar.com. And trust funding is what we're going to be starting with today. So let's go ahead and we'll get those slides up and running.
Also, I'm gonna put this link that you gave us.
Okay, yeah, there's a link to that whole thing that I just kind of read off of that Shalene's putting into the chat, so you can download that PDF of that one pager that's got all the links in there. And everybody who's attending in person, you'll get it in an email tomorrow, correct?
Yes.
All right. All right. All right, so what is trust funding? Trust funding is taking those tasks that are necessary to transfer ownership of property into the trust. And this is a huge problem that I see all the time. People look at a revocable living trust as some kind of magic box where you just sign the papers and suddenly everything avoids probate, and that's not the way it is. Look, here's the secret that I end up telling my clients, and I wish more attorneys would actually explain it this way. Here's what probate is. Probate will take something from a deceased person's name, run it through the paperwork mill, and we need all these inventories and copies of canceled checks, and we need the invoices, and everything's got to balance down to the penny, and then out the other side, it retitles assets to the names of the beneficiaries. So all probate really is a massive, expensive, time-consuming, frustrating, and public retitling process. So the revocable living trust is your base for keeping things out of probate. It's the base of your plan, but you have to think about it like a suitcase. You can buy and build the best suitcase in the world for your clients, and they can get that suitcase, they can go on a trip, they get to their hotel and they open it up and there's nothing in there. And don't start yelling and screaming at the suitcase. You didn't pack the suitcase.
If you think it's important for educational videos like this to get out there, then please help us out by subscribing to the channel.
So that's really what we're talking about today with trust funding. It's packing the suitcase, transferring ownership of certain things, setting up the beneficiary to go into the trust, or setting up the beneficiaries to be consistent with the overall plan, but there may be some tax and other reasons to do things a little bit differently. And as we go along through the slides, I will address those. So how important is it? Failure to fully and properly fund the trust could result in some or all of the trustor's property being subject to probate, thereby defeating the purpose of using a trust in the first place. If you don't fund the trust, all you have is a much more expensive and wordy will, because everything's still going to have to go through probate before it gets over to the trust. Now, can you fund the trust with absolutely everything? Don't ever guarantee to your clients that everything will avoid probate, because there's stuff that will pop up that was never intended. And the easiest example I give is if you have the unmitigated nerve to file your taxes and die before you get your refund, oh my gosh, they will not issue that check to your trust. It's going to issue it to your estate, which means it has to go into probate. But that's the odds and ends stuff. Oh, I had this $25 account at the credit union because I had to have that account to get a great rate on a car loan. Fantastic. If you didn't move that into the trust, okay, that ends up going through probate. The thing is, you want to make sure that the biggest items are avoiding probate as much as possible. So, some funding misinformation that's out there, and unfortunately there are attorneys who either don't know this or they're intentionally saying things like, okay, leave the cars out, don't worry about it. Now, I'm going to give the big exception in North Carolina. I have heard nothing but horror stories about North Carolina with getting your vehicles transferred into the trust. That's the exception. If you're not in North Carolina, I haven't heard of too many real difficulties. And there's also a workaround for that in North Carolina. It's, look, if you're going to go buy a car, the 3 pains that my clients have reported, the DMV doesn't know what they're doing and it's frustrating. My auto insurance person doesn't know what they're doing with this because it's a trust. They keep trying to tell me it's a commercial vehicle. And this actually happened to an attorney who funded his own car into his own trust. The tax office for the county kept double billing them for the same car and the same VIN number, one in his name and one in the trust name. Well, if you're going and you're buying a new car, you negotiate your price, you work with the dealership, you get, okay, I'm ready to buy, I'm ready to sign. However, dealership, I want you to title this the name of my trust. Here's my abstract of the trust. And here's the information for my auto insurance person. You make sure that the auto insurance is transferred to this vehicle. And if you can do that for me, then we've got a deal. Well, now you've just kind of offloaded 2 of those 3 big things onto the dealer to get it funded into your trust. And there's no issue with double billing with the county tax office because it's a car that's coming into your name. Problem solved. So there are workarounds. Oh, leave bank accounts out. Yes, we got a question.
So Heidi says in Scottsdale, Arizona, you won't be served with photo tickets if the car is in the trust for the loss.
Well, okay. I have avoided criminal law, but we have, Heidi has said that if you have those kind of photo tickets, because you might have gone through a yellow light that was a little too long and it was red, and well, maybe you went through it and flash, you get a photo. Well, if it comes up and pops up that the car is in the name of your trust, Heidi's saying, at least in Scottsdale, they just kind of ignore that and don't worry about it. Okay. I'm not, again, not giving any kind of criminal law advice. It's definitely out. Leave bank accounts out. Well, no. Occasionally, I get this from credit unions that they're like, well, okay, if you want to have the benefits of being a credit union member, you need to have one account in your name. Usually, they'll also set up another account in the name of the trust. But these credit unions, the big one near me is like State Employees Credit Union. I think you need to have $25 in their share account. Okay, keep $25 in a share account in your name and then put everything else into the accounts that are titled in the name of the trust. A letter will just change the ownership. No. And this is something Bobby covered yesterday because there are some form letters that come with the trust. This is to, quote, get the ball rolling. You send those letters into whatever financial institution or other entity. They'll go, oh, okay, we know what you want to do now, and then they will send you the forms to get things going. Oh, Schedule A and B transfers ownership. No, it doesn't. Now, this is something that I ended up having to do a bunch of research on because of a probate that I had to deal with, an ancillary probate. This is a California thing. California, if you have a revocable living trust and you have Schedule A and you list that here's stuff that's owned by the trust, but you never actually do the title transfer paperwork. You don't actually pack the suitcase. California has a separate type of probate light where you can go in and show, oh, well, the title didn't happen, but Schedule A says that this is owned by it, and the judge will go, okay, well, it's only going to cost $50,000 instead of $250,000 or $300,000 for this probate, so okay, we'll just rely on Schedule A. No, look, pack the suitcase. Actually do that stuff. That Schedule A stuff in California is a backup. And the trust does not have to be fully funded because there's a pour-over will. Well, the pour-over will is the just in case you didn't pack everything. I don't know, for the people here, did you pack absolutely everything or did you end up having to buy something? I know I had to buy something. I needed a charging cable for my actual battery. And Amazon is nice enough to have one of those mailbox things here. Okay, that's quote the pour-over will. It handles this stuff that might be forgotten or like the refunds from the IRS after you file your taxes. The pour-over will make sure it goes over to the trust after probate. But that pour-over will does mean if you're going to rely on it, it means probate. Okay, that's not good. Oh, did it go too far? Okay, so these are the probate letters that kind of come along with the trust. I'm just going to flash through them because, like I said, this is the get the ball rolling stuff. And here's a declaration of revocable trust. I believe Bobby also mentioned that this is something specific to Texas. It just helps out by filing that. Declaration of a revocable trust, also Texas. And we're going to get to the abstract in a minute. Now, trust funding, whose responsibility is it? Well, look, it's the trustor's responsibility. It's their estate plan. But as the attorneys and the advisors who are working with our clients, this kind of becomes our responsibility as well. Now, what I typically go over with my clients, we offer an option for us to do that paperwork. But believe me, it's out of what I do every day. And so I'm charging a significant amount of money to the point where my clients don't want me to do it. But I will work with the financial advisor and come up with the actual checklist of recommendations for each account and each asset. And I have a separate trust funding meeting, usually in conjunction with the financial advisor, or they'll handle it and we'll collaborate. So we have the checklist. But as financial advisors in particular, This is your option. This is your way to potentially gain some financial business. There's another member, a financial advisor out of Texas that I know, Eli Combs, and his whole thing is, look, if there is money in motion, there's an opportunity for you to help these clients, but also to gain some financial business. This is money in motion because you're trying to get assets over to the trust, and you might be able to make some suggestions for here are some things that might work better for you. And that's why a lot of financial advisors want to work with revocable living trusts with their clients. It gives them this opportunity, and they know it's going to be helpful to the client and their families afterwards. So as the advisor, assist in this process. Now, the other thing, and this kind of irks me because I've had a few advisors that I'm not working with anymore in this system. Oh, well, I'm not doing anything financial with this particular account, so they're on their own. No. Look, if you have someone, a client, and it's like, okay, here's what you need to do for your bank accounts and to handle this with the bank accounts, and they're having trouble, and you go with them down to the bank and help them out, that's a client for life. That's a client who's going to end up sending you more business. And if they were just going to give you maybe this one account to do some investing with, they're going to trust you because you're helping them out with something that you didn't have an obligation to do. And you're just being a good advisor. So go ahead and do that. Assist them with getting the information to put all of this stuff together, but then also assist with the transfers if you can, even if it's not something where you're going to profit specifically off of that. So here's just something to potentially give the clients to gather up the paperwork. Now, I use a fill-in form, and I rely on that and whatever the financial advisor may also collect when we're putting together the recommendations. So there's the asset information, there's the debt information, income sources information. Now, this is for funding a revocable trust, but I can tell you all of those things also become highly relevant if we're going to ever talk about Medicaid planning. So just keep that in mind. You're going to definitely need a lot more details if you're talking about Medicaid. All right, so information that's needed by third parties. The trust name, the trustee's name, tax ID, and the trustee powers. I'm going to talk a little bit about the tax ID thing, but that's all stuff that's in the trust abstract. So financial institutions, again, we'll get over to that, sometimes they'll ask for a copy of the trust. Well, okay, in the abstract, and if they just take the piece of paper, then that's all they're doing, they're just checking it off. You don't have to give them all those terms. If they say, no, we need a copy of the trust, well, then you can talk with them and decide do they only need certain pages, what do they actually need. A lot of my clients, if it's like their financial advisor who's handling investing and who's handling annuities and even stocks and whatnot, they usually don't mind giving them the whole copy of the trust at that point. Tax ID numbers. Don't ever let someone at a bank or a financial institution tell you you need to go online and apply for a separate tax ID number for this trust. This is a revocable grantor trust. As Bobby said, it's see-through. All they really care is about the taxation. So it's a social security number. This is the easiest rule of thumb. If you're taking assets and moving it into this new revocable living trust, and it's for a couple, just keep the social security number that's already on the account. The bank doesn't really care, is it the husband or is it the wife, who's the primary way. All they care about is who's getting the 1099s and the K1s so that they're reporting things and the income taxes are going to be paid by the proper person. So just keep using that social security number. Now, if one spouse passes on, that's another whole thing where you're going to need, for that B trust part, you're going to potentially need to have a separate tax ID number. But up until that point, don't do it. What it's going to end up doing, because it's real easy to just go online and get an EIN, you're going to have significant problems, probably for several years, trying to tell the IRS, no, I don't need to file a 1041 tax return because this is a revocable grantor trust. So again, just keep it easy. Use the same social security number that's already on the account as you're moving it in. And again, here's the abstract. You always give that, and if they ask for a copy of the trust, and keep your fingers crossed that that's all they want. In my experience, it's at least half the time they go, oh, okay. It's got the stuff that they're generally looking for.